Professor Trinton, in his work Law of Contracts, defined acceptance as a final and unqualified assent to the terms of the offer. Also, ordinarily in Law of Contracts, an acceptance can be defined as the unqualified agreement to the terms made by the offerer to the offeree. But I want you to know that definition of acceptance goes beyond just that, and as a law student you need to go beyond just defining to your lecturer what an acceptance is. That's what we are going to consider in this very video. We are going to consider everything that surrounds acceptance as an element of contract. There are some valid conditions that has to be in place for you to actually say there is a valid acceptance, and that is what this video is basically all about. We are going to solve all those conditions. We are going to see all those conditions with cases and authorities that illustrate a principle whereby you could actually say there is a valid acceptance. And of course, once there is a valid acceptance, there is a valid contract. However, if you are new to this channel, I encourage you to subscribe to this channel, King's Advocate Network, because every week we post a video here, be it on law of contracts, be it in other aspects of law. So if you wish to be receiving updates, I encourage you to subscribe and turn the notification button so that every week when we post a video like this, you will be the first person, you will be among the people to receive it, so that you'll be able to watch it and see how that helps you. Having said that, let us proceed to number one condition that has to be in place under the law of contract for an acceptance to be a valid one is that it must be unqualified and absolute. What do we mean by that? Acceptance must be unequivocal and match the terms of the offer exactly. Any modification or condition attached to the acceptance makes it a counter offer rather than acceptance. All this simply means that when you are talking about an acceptance, it must be unqualified. It must be unequivocal. Everything must be expressly accepted as the way it is. There is no room for, yes, I accept this, I accept that. I will give you a typical example. For instance, if Mr. Stanley promises or made an offer to Miss Clara that he wants to marry Miss Clara, and then Miss Clara, on the other hand, instead of accepting it, say that, okay, I will marry you, Mr. Stanley, but on one condition. You are going to send me abroad, let me further my education, let me complete my LLB, then I'm going to marry you then. This thing, of course, is not a valid acceptance. There has not been an acceptance. Although Stanley made an offer to Miss Clara that he wants to marry Miss Clara, Miss Clara in this case didn't accept. What Miss Clara has done is what we call counter offer, and our video next week will be on issue of counter offer, whether counter offer is a valid one or not a valid one, and there are many cases to that effect. That is what we are going to consider next week. Let us focus on what is facing us, which is the conditions that has to be in place for a contract to be a valid one. Like I pointed out through this example, what has happened between Mr. Stanley and Miss Clara is not an offer. And let me remind you, of course you know that a promise to marry is a contract. A promise to marry is categorized as a contract. If you want to see a video that has to do with that, I encourage you to click the video above, or after watching this video, go to my playlist. Don't be distracted. Let us face this one first. Then after watching this video, check my video that has to do with breach of promise to marry. So in this case now, there is a contract. I'm trying to tell you that a breach of promise to marry is a contract. And in this case now, Mr. Stanley has promised Miss Clara that he wants to marry Clara, but Clara didn't accept unequivocally or unquantified. But what Clara is saying now is that I will marry you, but on this condition, if only you will send me to abroad. So what has happened is not a contract. What has happened is not a good acceptance. It's invalid acceptance because there is a condition attached to it. Are you getting my point? I hope this example is clear to you. What this thing is saying is that for an acceptance to be a valid one, you must accept it. It must mirror the offer. That is what Professor Sege said. It must mirror the offer. It must mirror everything that has to do with. There is no room for I accept on this condition or I accept on that condition. It must be all quantified. There is nothing like checking the other side. I accept. I want to sell this car for 1.5 million. All right. Where is your account number? Let me make the payment. There is a contract, there is offer, there is acceptance, and there is a contract. But if I want to sell this car for 1.5 million, well, I don't think this car worth 1.5 million. Can you sell it 1.2 million? In this case, the other person, instead of making an acceptance, has made what we call counter offer, not an acceptance. That is what one condition that has to be met. Acceptance must be unquantified. Acceptance must be unequivocal. And acceptance must be absolute. And to add a flash of authority to this, because I promise you that what we are going to do is that any rule we state the authority to it. I have a case here, which is still a case of Oriental Bank PLC and Benante International. It's a case I mentioned in my earlier video introduction to contract as well as offer. But this case still applies. It cuts across all elements of contracts. In that very case, Nikitobi JSC of blessed memory not only took time to define what a contract is all about, but he provided a look to the whole element of contract. Let us quote him verbatim to see what he says that an acceptance is. According to the learned justice, an acceptance is a reciprocal act or action of the offeree to an offer in which he indicates his agreement to the terms of the offer as conveyed to him by the offerer. Very important, as conveyed to him by the offerer. What this means that whatever you are accepting, it must be wholeheartedly. I agree. Will you marry me? Yes, I agree, my love. There is nothing like, please let me ask my mommy, let me ask my daddy, let me go to school. No, I accept that you are going to marry me. That has become an acceptance. Of course, you know, offer and acceptance is just two elements out of the many other contracts. But if you go to the contract law, if you go to the cases in contract law, all the breaches normally arises either in offer or acceptance or consideration or absence of intention, what we call as consensus ID, the lack of absence of meeting of the mind. So all of them emanate from this breach. If you present a case to the court then will inquire or look into the whole case to see if actually there is a breach somewhere. And then I have given you a first case, right? Another case to support this, your idea that offer must be absolute and unqualified, is the another case of Benante International Limited vs Nigerian Deposit Insurance Company. This one was decided in 2011. Remember, the other one is Orient Bank and Benante International. And this one again is Benante International Limited and Nigerian Deposit Insurance Company, NIDC. In this case now is where Adegoke JSC took time again to say that for an acceptance to be a valid one, it must be unconditional. It must be unconditional. According to learned judge, he stated that for an acceptance to be a valid one, it must be unconditional and unquantifiably accepted. I hope you get that gist. For an acceptance to be a valid one, in synchronization to a valid offer, it must be that which is wholeheartedly accepted. So two cases here, Bank International and Benante PLC, and Benante International Limited and Nigeria Deposit Insurance Co Limited. So these are the two cases to back it up. There are more cases you can use to illustrate this point that offer must be unquantified and unconditional. Now we'll proceed to the second conditions that has to be in place for you to say actually there is a valid acceptance. Number 2, silence does not constitute acceptance. Silence does not constitute an acceptance. This simply means that the offeree must indicate his assent either in words or in writing or by conduct. So as a general rule in law of contract, a mere intention to accept does not constitute an acceptance. So it is a general rule in law of contract that your intention to accept does not constitute an acceptance. And a common law locus classicus case to this effect that silence do not constitute an acceptance is the case of Fenthams and Beatley. In that case, the court ruled the fact that if somebody is silent as to a particular offer, that does not constitute an acceptance. However, it is important for you to know that in every rule, there is an exception, especially when it has to do with contract law. Every rule in contract law has an exception. There are 4 exceptions whereby your silence could be interpreted to be an acceptance. And of course, you remember the lactim maxim qui texet consenta videtur, meaning that he who is silent is deemed to agree, or who is silent is deemed to consent. That means that there are some certain exceptions whereby your silence could be interpreted to mean an acceptance. I will give you an example. For instance, your mother deals on vegetable, and every morning your mother delivers vegetable, every evening your mother delivers vegetables to a particular customer. And sometimes she may go there and she will not see anybody. Maybe they are going for a school run or they are doing anything. She will kindly drop a vegetable at a particular spot. That has been the rule. That has been how your mother has been transacting with a particular customer for days or for decades. Then when it reached a particular day that your mother delivered a vegetable at that spot, the person she delivered to then claimed that on that day she doesn't want to accept vegetable again, that she didn't intend to cook that day, or she didn't intend to make any transaction with vegetable that day, and your mother has delivered it. The court in this very scenario will not be easy to hold. There is not a contract. because it has been a custom between your mother and that very customer that every morning or every evening she delivers a vegetable to her. This applies to all things. I'm trying to give you an example. So if it's something that is perishable and such a thing has spoiled, that customer will be held liable to pay damages to your mother because there has been a breach of contract here. That is what this thing is saying. If there has been, this is an exception to that rule that silence do not constitute acceptance. If there has been a custom and the court has taken a judicial notice of that very custom, that this is how you people do your business or transaction, the court will not feel free to hold based on the decision in Fed House and Bitley that silence do not constitute an acceptance. The court will not hold that. The court will examine it under the fact of each case to actually say there is acceptance or there is no valid acceptance. And now we'll proceed to the third condition that has to be in place for you to actually say there is a valid acceptance. And that one is the one developed by the court over the years, which is postal rule acceptance. You may have heard that. Postal rule acceptance. Postal rule acceptance is simply to the effect that when acceptance is communicated via post, the acceptance is deemed to complete as soon as the letter of acceptance is posted, even if it is delayed or never reach the offeror. I hope you get that gist. This is to the effect. This postal rule acceptance for me, as far as I'm concerned, is no longer obtainable. This was more obtainable in that ancient days whereby people would deliver a letter to the postal service and the letter is going to take years. If it's a letter that is going to outside of a particular nation, the letter is bound to even take years, take months before it delivered to the right parties. In this case, now what the court will check is the very day if you have made an offer to somebody and that person, the only transaction, the only way you people communicate is through the letter. The day that person accepts it via his own letter is the day the offer and the acceptance becomes a valid element of contract on that particular day. Regardless of whether you have received the letter to actually see that the person you offered have accepted, no, the court will check it from the day the person penned that very letter down, letter of acceptance. But this is no longer obtainable. However, your lecturer will still ascertain you on this because contract law is a common law course, is a common law is a common law origin, and everything your lecturer will examine is your deep understanding, regardless of the fact that postal rule is no longer obtainable. Postal services due to internet has taken over, all these things are no longer obtainable, but yet the lecturer will examine you to test your ability to appreciate when contract is valid, when an acceptance is valid, and when there is no acceptance. All these things are hypothetical in nature. If your lecturer paint this scenario, it is left for you to actually know that in a postal rule doctrine, it simply means that when you have made an acceptance via your letter, that very day it becomes binding, regardless of whether the offerer have received it or not. And the locus classicus case here is the case of Adam and Lise. It's a case that all law students know. It's a case of Adam and Lise, decided 2 centuries ago. It is a locus classicus case to the effect that acceptance took place immediately you endorse it through your letter writing, regardless of whether the offerer have received it or not. We still proceed. Number 4, prescribed mode of acceptance. Like I said in my previous video when we talk about offer, and if you want to watch another video like this on offer, kindly click the link above. That video also dealt with the issue of offer. I told you in that case that according to Lord Daniel of Blessed Mary, in case of Torre and Manchester City Council, he stated something that is very important for all law students. He said that you do not look into the minds of the party to actually say there is a contract, but rather you look at the facts and conduct of the parties to the contract. How does this got to do with this number 4, which is prescribed mode of acceptance? What I'm trying to say here is that in every contract there is agreement. If this party has prescribed that this will be the way that will guide the acceptance, that becomes the way the acceptance will be made. Like I always do here, I always give you a claim to back up what you have said. In the case of Manchester Diocesan Council of Education and that of Commercial Investment Limited, in that case, the court held that if there is no prescribed mode of acceptance between the parties, any other mode of acceptance is valid, provided it is not contrary to all the enumerated elements that guides the validity of acceptance. Any other mode is accepted. But if the party has prescribed between themselves a particular mode, any other mode is null and void, as I mentioned earlier. Now we proceed to number 5 condition. This one is called instantaneous communication rule. So instantaneous communication rule is to the effect that for method of communication that are instantaneous, example, telephone, fax, email, or other internet services, acceptance is only valid when the offerer actually receive it. I hope somebody get my point here. You see that instantaneous communication rule is against postal rule. Do you see it? It's actually against it, and I even want you to tell me how it is against it. Put it in that comment section. It is actually against it because the other one of postal rule is to the effect that whenever you have made your acceptance via your letter, whether the letter has delivered to the receiver or not, that does not matter. It becomes binding. But this instantaneous rule is to the effect that the person you deliver to the offerer must receive it before it becomes binding. And a locus classicus case there is the case of Entores Ltd and Miles Far East Corporation. In that case, Lord Denny held that for a contract formed by instantaneous communications, acceptance is complete only when the offerer receives it. I hope you get my point. According to Lord Denny, he held in that case that for a contract that are formed by instantaneous communication, acceptance is complete only when the offerer receives it. That, I believe, ends this number 5th, which is instantaneous communication. And I believe now you have actually got the point we mean in that very case. So now we have seen it. And then I will leave you with a question, which is very important. I want you to answer this question in the comment section. Do you think actual communication of acceptance is necessary in all cases? Haven't watched my video on offer, and if you have not watched that video, click the link above to watch that video. Haven't watched my video on offer, do you think that actual acceptance is necessary in all cases? Must you communicate your acceptance in all cases in law of contract for it to be binding? Or do you think there are situations whereby pronouncement of acceptance is not needed? Put it in the comment section and I'm going to see your view on that. My next video on counter offer, I'm going to start by answering this very question. I encourage you to check out that video next week. But if you want to watch my video on introduction to law of contract, click the video above. We also made a video on offer. Check out this video, and this video is good. Two of them is going to help you to understand this topic better. Thank you.